And that is the true implementation of Article 14 of the Constitution of India, which speaks about equality. That's what the Supreme Court has said in many judgments. And unfortunately, the departments, the governments do not pay attention to that at all. Mushtaq Hukeri has a question. He says that, now let me read that question for you so it will become very clear. Sir, what to do if Supreme Court judgments are not followed in department to give justice to employees? Higher officers are not following case law judgment. Please reply. This is a very unfortunate situation that occurs many times, my dear friends. Government officers, though they know various case laws, are really not ready to apply them in a particular situation and to do justice with its employees. In fact, there is a catena of judgments. There is a considerable number of judgments of the Supreme Court in which the Supreme Court has held that the state, which includes, of course, the government, the local authorities, the statutory authorities like the university, municipal council, Zilla Parishad and all that, those local self-government, whatever comes within the definition of state has to act as a model employer. That means the government and the other local self-government bodies, the state, has to act in a very, very fair manner with its employees. The Supreme Court has gone to the extent of saying that if one set of employee has already approached the higher court or any court and has obtained a particular order in its favor, then the employer's duty is to give benefit of that judgment to another set of similarly circumstanced employees, even when they have not gone to the court for getting the same relief. It is the duty of the employer to apply the judgment of the High Court that is delivered in one set of employees to identically situated another set of employees. And that is the true implementation of Article 14 of the Constitution of India, which speaks about equality. That's what the Supreme Court has said in many judgments. And unfortunately, the departments, the governments do not pay attention to that at all. There may be other areas where they are doing injustice. Take a case contemplated by Mr. Mushtaq Hukeri, where he says that in spite of existence of Supreme Court judgments which binds the department is not acting on it and not giving benefit of those judgments to the employees. So he wants to know what to do.
इस वीडियो में दी गई जानकारी आपके केस की कानूनी सलाह नहीं है. The information provided in this video is not the legal advice of your case. या व्हिडिओमध्ये दिल्या गेलेली माहिती ही आपल्या केसचा कायदेशीर सल्ला नव्हे.
Now the answer is, this is really an unfortunate situation, but it's not that you can do nothing in this situation. What you can do is to first make a proper representation, draft a proper representation, include in that representation the citations of the case laws of the Supreme Court, the point involved in that case or in those cases, and how that point is applicable to the fact situation in which you want the government officers or the department to apply it. Explain everything in that draft, in that representation. Make a proper conclusion prayer. In that prayer, call upon them to apply that particular established law to the fact situation at hand and to do justice with the employees, and submit that representation. Maintain evidence of having submitted that representation to that particular authority and wait with an expectation that they will read that and they will do justice to the employees. Now suppose that the department, in spite of receiving that representation, absolutely does not pay any heed to it, absolutely does not implement it, then you have a base ready with you for stating that in your petition before the concerned court, maybe in high court, whatever court you will approach. You have a foundation ready. You can tell the courts that you had brought these case laws to the notice of the authorities, and in spite of that they have failed to act upon it, that they have failed to perform their duty of applying the ratio, applying the law delivered in that case or declared in those cases to the fact situation of your case, or I mean the employee's case. There is a failure of performance of their duty. This will become one additional ground in your case that you will be filing before the court. Now I know I have worked on the government side for quite a long time as a government pleader in High Court, and it has been my experience that in spite of realizing that the employees need to be given benefit of a particular legal provision who has already filed a case in the court, the department is very reluctant in granting those benefits at their own level. Rather, that would be the best practice. That would be acting in fairness. The right thing to do in such situation is to, having realized the fact that they are really deserving that benefit, to apply those principles to them and to give them those benefits, actually resolve their problems, and to make a statement in the pending case before the High Court or Supreme Court, whatever, by telling the court that the department has already redressed the grievance of the petitioner and the petition no longer survives. This way, one petition can come to an end. But unfortunately, of course, there are good officers. I'm not saying that all are not sensitive to those things, but majority of them I have found have great reluctance in doing so. Their stance is that let the court pass an order and then we will do it. So they want to rest on the shoulders of the courts, which is really not appreciable. So, Mr. Mushtaq Hakeri, this is what you can do in your matter if the government officers are not paying attention to this case laws of the Supreme Court. Hope this helps you.